We'll call the meeting to order. This is the Standing Committee on Citizenship and Immigration, meeting number 58, Wednesday, November 7th, 2012. This meeting is televised pursuant to the order of reference of Tuesday, October 16th, 2012, Bill C-43, which is an act to amend the Immigration Act. Ladies and gentlemen, as you know, we have bells at 5:15. We have some business the committee's going to have to look at for 5 minutes. So this meeting will end at 5:10, which means the first group will have a total of 55 minutes. The second is just one witness who will have 45 minutes. So that's how it's going to work. So this first hour will end at 4:25. We have two witnesses with us this afternoon, two lawyers with the Canadian Bar Association. We have Kerry Frock, who is a staff lawyer with the Law Reform and Equality, and we have Michael A. Green, who's a member of the National Immigration Law Section. Good afternoon to the two of you. Thank you for coming. We have all the way from Winnipeg, Manitoba, Mr. Lamoureux, a witness who's an immigration lawyer, and I'm going to try my best, sir, to pronounce your name, Ronaldo Reyes Becerra Jr. Paquetan.
Paquetan, sir.
Paquetan. We'll call you Mr. Paquetan. Is that good?
Paquetan.
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 Paquetan. Well, we'll get it. So, sir, we'll let you go first. You have up to 10 minutes to make a presentation. Mr. Paquetan.
Oh, thank you. Thank you, Mr. Chair. Before I begin, I would like to thank the committee for inviting me to appear. The last time I recall attending a House of Commons committee meeting was when my father served as a member of Parliament. It is humbling to contribute to the work you do in service to our country. In my view, while not perfect, there are portions of C-43 that deserve support, portions that should be amended to reflect greater fairness, portions that should be eliminated, and portions that members of Parliament should turn their mind to, as they will necessitate further study. The portion of the bill that deserves support is the provision that eliminates the right of permanent residents to appeal removals to the Immigration Appeal Division for sentences of 6 months or more in prison. While some argue that this would unfairly penalize long-term permanent residents who may be deported for their actions, what is missed in this argument is that the permanent residents who will face deportation are criminals. It should be stated that these individuals are not alleged criminals. They are not the accused. They are not innocent. They have been convicted of a crime in a court of law. Members of Parliament should keep in mind that to be found guilty of a crime, an individual not only has to commit a criminal act, but must have knowledge of what they are doing. Unless this combination of factors is found, there is no crime. Members of Parliament should also keep in mind that criminals could avoid deportation by simply being law-abiding. Our Canadian Criminal Code is designed to codify what we Canadians view as criminal behavior. These individuals have chosen the path of criminal behavior. In addition, these criminals were given due process as required by our court system. Members of Parliament should keep in mind that these criminals were initially presumed innocent, were given the rights under the Charter to defend themselves in the court of law, were then found guilty by a jury of their peers or a judge, and lost their appeals if they wished to file appeals. Furthermore, we are not talking about criminals who have received only alternative sentences, fines, or probation. We are talking about criminals who have not only been sentenced to jail, but sentenced to at least 6 months in jail. We are also not talking about criminals who did not have the ability to argue their immigration status at the time of sentencing. There are numerous court decisions, including decisions from the Courts of Appeal in Ontario, BC, Manitoba, Alberta, the Northwest Territories, and Nova Scotia, that state that immigration consequences are a relevant factor in sentencing. To say that convicted criminals have not had their day in court is inaccurate. As members of Parliament know, before a criminal is sentenced, judges must take into account certain principles. These principles are set out in Section 718 of the Criminal Code. Under the Criminal Code, judges must take into account the possibility of rehabilitation and mitigating circumstances. In fact, the Criminal Code specifically states that, and I quote, "An offender should not be deprived of liberty if less restrictive sanctions may be appropriate." It also states that, and I quote, "All available sanctions other than imprisonment that are reasonable in the circumstances should be considered for all offenders." Permanent residents who commit crimes, like Canadians who commit crimes, know the crime they are committing. One portion of the Act that requires amendment, though, is the 5-year bar that will be imposed on a foreign national for misrepresentation. Unlike the criminal provisions, the misrepresentation bar can penalize the innocent. Under the law, the general rule is that an immigration misrepresentation can occur without an applicant's knowledge. In fact, there are cases where misrepresentations have been found when the applicant is the victim of shady representatives who have acted without the applicant's knowledge. In these cases, C-43 would penalize the innocent. A simple amendment to C-43 that would result in the bar of misrepresentation applying only to misrepresentations made knowingly would be fairer and more consistent with Canadian values. The portion of C-43 that should be removed is the section that would allow the minister to deny entry to temporary residents on the basis of public policy. This section is troubling in that the ministerial discretion opens up the possibility of decisions being made without clear criteria. Canadians are entitled to know what actions could cause a person from being barred from coming to Canada. In the departmental backgrounder that was published in June, the department cited the example where the minister could bar a foreign national from entering Canada who would promote violence against a religious group. If promoting violence is criminal, these individuals, when they enter Canada, should be arrested and should be charged. However, the decision on arrests should not be made by a political actor, but the professionals in the judicial system, such as police and crown attorneys. If the conduct of a foreign national is criminal, he or she should be arrested in Canada. If not, he or she should not be prevented from entering Canada. The last aspect I would like to touch on is the sections of C-43 that deal with employer compliance. I realize that this section of the bill, which is section 37, deals only with the ability to create regulations with respect to foreign workers and their employers, amongst others. I also realize that before these regulations are enacted, Canadians will have the ability to comment on these proposed regulations. However, members of Parliament should be given thought, or should be giving thought, as to what sort of conditions should be imposed on employers of foreign workers and penalties for noncompliance. Over 180,000 foreign workers are in the country at any point in time. This is a large component of the workforce, and certainty is needed for both employers and employees. As a result, before enacting such regulations, widespread consultation with business, labor, and other groups will be necessary. Thank you, Mr. Chair, and I'm open to questions from members.
Thank you, Mr. Pagtacan. Ms. Frock and Mr. Green, you have between you 10 minutes to make a presentation.
Yes. Thank you, Mr. Chair and honourable members. The Canadian Bar Association is pleased to appear before this committee today to address Bill C-43. The Canadian Bar Association is a voluntary association of 37,000 lawyers across Canada whose primary objectives include improvement in the law and the administration of justice. It is in the spirit of this mandate that the members of our immigration law section have analyzed Bill C-43 and make the comments that we have submitted to you in writing and will speak about today. Michael Green, a member and past chair of the immigration law section, is here with me today, and I'll turn things over to him to address the substance of our comments on the bill.
Thank you, and thank you to the committee for inviting us to address you today. I'm Michael Green. I practice immigration law in Calgary. I teach immigration law at the Faculty of Law at the University of Calgary. I was the national chair at the time of the introduction of IRPA, and so I appeared before this committee on very similar provisions. In fact, the 2-year bar, I appeared before this committee, as that was part of the presentation we made at that time, and you might guess we weren't in favor. In any event, we recognize that in order to maintain public support for a robust immigration program, Canadians must feel confident that we are tough on those who would abuse our immigration system. The minister has been effective in this regard, and we applaud his efforts in particularly going after citizenship fraud, permanent residence fraud, marriage fraud, and the activities of crooked consultants. Unfortunately, we cannot support this legislation. In our opinion, Bill C-43 is an unnecessary exercise and comes at an unacceptable cost to basic Canadian values of justice, fairness, and compassion. While we believe it is a good thing to limit most forms of temporary inadmissibility to just the individual involved rather than their family members, our endorsements or positive comments essentially stop there. Unlike most other immigration reforms proposed by this government, this bill was not the result of public consultations, was not subject to consultations. In our opinion, this is a recipe for bad law. We know that you are under considerable pressure to pass this bill through committee quickly. We urge you to take your time and consider the bill carefully. The problems in this bill, we believe, are substantial enough to warrant careful deliberation and debate. We already have sufficient and effective tools to keep out foreign nationals with criminal backgrounds and to expeditiously evict those who commit serious crimes after their arrival. Much like the problem with citizenship fraud, the problem lies not with the law or the tools available to the department, but rather in the setting of priorities and the allocation of resources to deal with those problems. The extensive delays cited by the minister in certain high-profile cases have much more to do with restricted budgets and resources of the CBSA than with deficiencies in the process. The recent elimination of 1,700 positions at the CBSA is likely to contribute rather than improve those delays. The examples of cases that have been given to show excessive delays in removal of permanent residents who commit offenses are not representative of the vast majority of cases. While this legislation may be designed to capture the most egregious cases involving serious and unrepentant offenders whose continued presence offends many Canadians, they will also capture much less serious offenders. This legislation would break families apart and negatively affect the best interests of the children involved. Fairness and due process are not loopholes. They are fundamental cornerstones of Canada's system of justice. The minister, in his appearance, commented and said that he believes everyone should have their day in court, just not endless years of days in court. However, these are not multiple appeals against removal or denial of admission under the family class. There is only one single appeal. As long as the department and the decision maker follow due process, their decisions cannot be reviewed. It is very rare for an IAD decision to be successfully challenged in court. Moreover, once the IAD has rendered his decision, there is no right for the person to stay in Canada. They cease to be a permanent resident. If they challenge in court, they do not get to stay here. If the CBSA lets them stay, that's a different choice, but they do not get to stay while protracted appeals come on. It's only if the court issues their own stay that they would be allowed to stay, and that would only be in meritorious cases. I would like to highlight a few elements of our submission. First, we'll talk about the elimination of appeal rights for permanent residents with 6-month sentences for crimes committed in Canada. We do not agree with Mr. Pagtakan. The Immigration Appeal Division, with respect, is not the problem. The tribunal review takes into account both concern for the safety of Canadians as well as concern for the immigrant and their families, their employers, their co-workers, their communities. Offenders who show a risk to reoffend do not succeed at these hearings. Those who are successful are almost always subject to terms and conditions that require good behavior and rehabilitation. And failure to comply will result in their removal. The IAD's ability to impose terms and conditions on a stay order is an incredibly effective enforcement and rehabilitation tool that we've seen many times. The success of the IAD is often seen in the successful rehabilitation of one-time offenders as a result of this process. The inclusion of conditional sentences in the calculation will target relatively minor offenders who have never spent a day in prison. So to be clear, that it is the bar that has been set here in this bill is not 6 months of incarceration. It's just a 6-month punishment. And that catches conditional sentences, which are normally considered to be very minor sentences by the courts. That's where somebody's basically given house arrest. At the very least, we think that the amendment should be introduced to make it clear that it covers incarceration only. The denial of access to IAD review to permanent residents whose inadmissibility is based on solely on foreign convictions or offenses would treat foreign convictions much more seriously than Canadian convictions, because there would be no regard for the sentence imposed or whether there was even a conviction. Foreign convictions and offenses often involve processes that are not, they lack the procedural fairness that exists in Canada. In the case of the way it's written, there's no consideration of the sentence received. It's just simply how the offense might have been prosecuted in Canada. For instance, using a false or fraudulent document is an offense under Section 368 of the Criminal Code of Canada. It carries a maximum potential penalty of 10 years. A 20-year-old permanent resident residing, let's say, in Windsor, who goes across to Detroit and sneaks into a bar borrowing somebody else's birth certificate, that is, presenting a false document, commits an offense. They could get caught, convicted, given a minor fine, and become inadmissible without any right of appeal. That's the way this section is drafted. We don't see any justification for including this here, for denying it in this case. But it gets worse. The bill would deny a right to appeal merely where a person is believed to have committed an offense, even without having gone through a judicial process and been convicted. They might never have been charged. It's purely the conclusion of an officer. And neither of those powers were in the bill before, just to be clear, that they have been added. They were not in the previous legislation, that is, foreign convictions and offenses as being automatic grounds. I want to comment on the proposed ministerial power to exclude foreign nationals on public policy grounds. And this one I would agree with Mr. Pagtakan. We believe this power is unlimited, it's unaccountable, it's un-Canadian, and it's unnecessary. It doesn't have a place in a free and democratic society that cherishes civil liberties and fundamental freedoms. It's wrong to say that the minister is currently powerless. We have 9 different inadmissibilities to Canada. We also have hate crime laws and anti-terrorism laws that specifically target persons who promote violence against vulnerable groups in society. Persons with track records or an intention to engage in hateful rhetoric in Canada are inadmissible under existing immigration laws. Also want to comment on the increasing the inadmissibility from 2 years to 5 years. As Mr. Pagtakan pointed out, one of the problems is unintentional misrepresentations, which the courts up to the Federal Court of Appeal have clarified. It can include an unintentional. You can make a misrepresentation, let's say, about a child you didn't know existed. When you fill out your application, you don't include a child. 1 minute? Thank you. And later it turns out you find out after the fact that you did have a child, an illegitimate child. That can cause you to be inadmissible. That shouldn't be punished by 5 years. And there are many others that are minor. Somebody who just embellishes their relationship history, for instance, but they are an illegitimate relationship. Lastly, the restrictions on humanitarian and compassionate relief for certain inadmissibilities, including organized criminality. Again, they're facially appealing, but may work injustice in many cases. A lot of the problem with a lot of these laws are they're designed for the really egregious cases that we can all agree on are really offensive and people want those people out fast or keep them out. But the problem is they catch so many others. People can commit organized crime just by acting in concert with somebody else in something like a property offense like shoplifting. That can be considered, and the CBSA has gone after those people for organized crime. And that's not members of the Hells Angels. It's just acting in concert with somebody else can be called organized criminality. Not often they do it, but I've seen it happen in property offenses.
Perhaps you can conclude, Mr. Green, please.
And that's, with the greatest respect, we believe the bill has enough flaws and shortcomings that it should be withdrawn or not proceed unless substantial amendments are made. We recommend it go through a more thorough consultative process so that different alternatives can be come up with. Thank you.
And thank you, Mr. Green, Ms. Frock. We appreciate the contribution of the three of you to this committee, and I know committee members have some questions. We'll start with Mr. Opitz.
Thank you, Mr. Chair, and through you. Thank you very much, witnesses, for being here today. We certainly appreciate your time and your effort and your insight that you're going to provide for us through our questions and your answers. I'll start with you, Mr. Green. Have you ever, because in your submission, you're talking about criminality of permanent residents, but when people come to Canada, should they even be considering committing crimes in this country? You're starting a new life in a new country. Now, why should these people be allowed to commit crimes?
Well, they shouldn't. And we have a criminal justice system to punish them, and we also have a deportation system to get out the bad ones. So, and I don't think we should abandon that. I think we should hold people to be accountable, and we're not saying that. The problem with this kind of a broad brush bill is that it doesn't distinguish between there's degrees. There are always degrees in these cases. And so I've been doing this for 25 years, practicing in this area. I've done many of these kind of cases. Typically, what we often see, and what the bill doesn't provide for, is the long-term permanent resident. So we see people who come here as children. And they're often infants even. And what happens is they come from different countries with different cultures. Their families have difficulty adjusting. The parents often work really hard and aren't around as much. There's sometimes conflict because the parents want them to maintain their cultural values at home, but these kids are getting westernized. Sometimes they have trouble adjusting in school. They start to act out, and they hang out with the wrong kids. Sometimes they drop out of school, sometimes not. And what I often see is these offenses are committed when they're like 18 to 21, in that kind of age range, when these kids, they think they're invincible, like all kids do. They think they're, they can do anything. And so they commit an offense. They get into the system. If they go through the IAD system and they show enough positive factors, they get terms and conditions imposed on them. And I've seen so many cases where the kids have turned their lives around. I've also seen cases where people didn't turn their lives around. At the appeal, it became painfully obvious that they hadn't turned their lives around, and they get on a plane back home.
Just the youth. I mean, that happens, and there's some of that goes on, and we understand that. But we're also talking about serious criminality. For example, we have several. There's one where he has 60 counts of fraud, forgery, conspiracy to commit fraud, obstructing a peace officer, failure to comply with court orders. That took over 5 years to remove him after the removal order was given. There's so many more, including, by the way, trafficking, murder, and so many other things. And as we've heard in the last number of things, including the murder of a police officer. So, and you did say in your submission that we do have, justice, fairness, and compassion in this country, and I believe we do. This is one of the greatest countries on the planet, and that's why people want to come here. And in fact, in the tens of millions. They want to get in. So are you aware, by the way, that in many other countries such as the UK, the US, New Zealand, Australia, they already have provisions in place to bar individuals who would harm the public interest and who are otherwise not admissible? In fact, some of those provisions in those countries are broader and more discretionary than under Bill C-43.
Well, if I may, I'll deal with it. You raised two different points. So
Sure.
when you talk about the serious ones, and I want to say that we're not saying all criminals get to stay. We're not saying that at all. It just said there should be a process. The most serious fellas should get expedited, and they should be made a priority. Now, if you look at citizenship fraud, we saw this go on for decades. How many people lost their citizenship for fraud? Almost nobody, until the minister said, I'm going after this. I'm putting the resources there, and we're going to go after it. 2,500 cases are getting removed. I can tell you that's sending shockwaves around the world, and we're delighted at his efforts to do that, and we're appalled that nobody else did it before. That was simply a resources issue. If you look at some of these serious offenders that the public is really upset about, some of the cases that have been cited by the minister, you prioritize them, and you put them in jail. If they're a danger to offend, you can detain them. We have that power to detain them. And believe me, then they want their appeals to go a little faster if they're sitting in the remand center somewhere. There are tools out there already. The problem is that the cases that get cited in support of this bill tend to be the most egregious ones, and forgetting what the effect is on probably the vast majority that aren't that egregious. And some of the cases, if you look at the Bayliss case as an example, where the police officer was killed, that wasn't a fault of the IAD process. What happened was that guy went through, he lost his appeal, he got ordered deported, he disappeared. And what happened was, because he disappeared, he eventually emerged with a gun in his hand and killed somebody. And that is appalling. But it shouldn't take that long. If you draw distinctions between the minor and the serious cases and go after the serious ones. Another suggestion you could have with the minor cases is let an officer impose the terms and conditions. Set up something like you do with bail now, where there are mandatory terms and conditions. And you have and then that way, if they breach there, on the minor cases, then they're gone. But whatever. Sorry about that. I took you on a long answer.
Because I only got 7 minutes.
Yeah, you don't get that many minutes. I'll just comment on your other comment about other countries. I'm not an expert on what happens in other countries. I can only say the one time I can recall the U.S. using this power is they kept Farley Mowat out of the U.S. Now, I don't know what his problem, his hate crime was, or whatever it was, maybe loving animals too much, but Farley Mowat got denied entry to the U.S. I don't know what other countries have.
I think they would tend to aim at somebody a little more serious than that.
I would hope.
But we're talking about the people committing crimes here. Have you ever spoken to victims groups or any victims organizations? about C-43 and what their views would be? Because you're talking about crimes that may not be as egregious, but hey, you know, if you defraud a senior citizen of their life savings, that may not be murder, that may not be a capital type of offense, but that's pretty serious to that individual because you've harmed them, probably irreparably. So have you talked to any victims' organizations about this sort of thing?
You know, in terms of we get calls from victims too, saying like this person has defrauded me, or you know, we see it in the case of marriage fraud, we see it in criminality too. Like this person doesn't deserve to be here. What can I do to get them out? And sometimes we are directing them to the CBSA to make complaints, and also sometimes to their MPs to say prioritize that case, get some pressure going on this to make this happen, because it is appalling sometimes to see that action not be taken.
Sure, you got calls, but have you actually reached out to any of these organizations?
Well, let me think about that. We don't, the Bar Association, in fairness, I don't think we've reached out to anybody on these things in the sense, except we draw on the experience of all of our members is what happens.
I'm afraid that's it. Ms. Sims.
Thank you very much, and I want to thank all our witnesses for appearing. Appearing before the SIM committee is always a challenge in itself, I found, but we do thank you for taking time out and coming to share your perspective with us. And your testimony, thanks for that. And we do actually share a number of concerns with the legislation before us, particularly the increased power that will be concentrated in the hands of the minister without any checks and balances. We also have been very clear that we're willing to work with the government to make sure non-citizens who commit serious, often violent crimes can be removed quickly. And I think I heard you say that as well, that there are ways that that can be expedited. But we believe that if you look closely at the sensational cases put forward by my colleagues across the aisle and the minister, and what comes to our attention is that the real problem appears to be lack of training, coordination and resources and border security. In today's Toronto Star, there is a case of a Chinese national who was able to enter and stay in Canada despite being wanted for a grisly murder. This was not due to a lack of legislative tools to deport him. It was because of a breakdown in border security. And another case, and you mentioned it as well, of course, is that of Clinton Gale, who was brutally murdered by Constable Todd Bayliss who brutally murdered Constable Todd Bayliss. And our hearts go out to his family and to all the police in Toronto. But once again, a federal inquiry into the case revealed that serious errors led to the delay in removing this serious criminal. A former Associate Deputy Minister even admitted that the department's priority at the time was to target unsuccessful refugee claimants who were on the run rather than criminals, because that way the deportation numbers were going to be higher. So it all depends on what your goal is. We believe the government needs to go back to the drawing board and address the lack of training, resources and integration of information and monitoring technologies within the responsible public service agencies we currently have. So my question to you, and I'm going to address them to Michael and Kerry, the first one. In your brief to the committee, you conclude that many of the proposed amendments are both unnecessary and unjustified. With a mind to some of the sensational cases I just mentioned, can you talk about how the current system could be improved without eliminating the right to due process being proposed in this bill?
When you go into the emergency room at a hospital, there's a sign on the wall. It basically says it's not first in, first out, or first served, first come, first served. There's a prioritization. There's a triage. What frustrates the heck out of me, and I do a fair amount of appeal work in my own practice, is that at the CBSA, partly because they're stretched, perhaps, there is no triage. I don't see the kind of triage that I think needs to happen. So all cases are treated the same. All you need to do is reorient your priorities in the CBSA hearings department, for instance, and say, we're going to identify those more serious offenses. Maybe it's the ones that get more than a 6-month sentence, and say, let's prioritize those for fast tracking. Now, you could even take it to another level if you want to treat it like you've done with the refugee reforms, and actually say, in those kind of cases that meet certain criteria, fast track them. We'll fast track them. the problem with it now is it just doesn't draw any distinction between those egregious cases and the ones that aren't egregious. We have, I've got to say, we do have some concern, and the problem with basing this kind of legislation on egregious cases is that many of them are just not appropriate. The Clinton Gale situation, for instance, is more of an enforcement problem than an appeal process, and it happened under previous legislation. The minister also brought up the Just Desserts case, which happened under previous legislation. 4 people were charged in that offense. 3 of them were convicted. All 3 were Canadian citizens. The one that wasn't a Canadian citizen is the one that was acquitted. So it's not really a very good example of the failure of the appeal determination system. The COSA case that the minister referred to, which did take years to wind through the courts, the problem with that case is it set a precedent for how the courts review administrative decisions in Canada. It is a fundamental case. I teach it in my law school class. It changed all the rules. And it was a principle of law case, and it wasn't COSA stringing out endless appeals. In fact, he won the early level. It was the good department that was challenging the decisions, not the individual. That's not a good example of the failure of our system. Not that there aren't failures, or not, but we have failures in the criminal justice system. We have people who get acquitted on technicalities or because of excessive delay. We don't say we're going to cancel criminal trials and take away the right to criminal trial because some bad guys get away with it. We have to have more faith in it. We have to look at prioritizing. Like I say, the other suggestion I had is, what about looking at the possibility of imposing conditions at the officer level? It would be a statutory amendment, but I think it could be done.
Thank you. You mentioned in your brief as well, I ran through it quickly, a number of suggestions for amendments to the proposed legislation. In other words, can you expand on these, and particularly, do you think we could change this bill to both preserve due process and deport dangerous criminals faster?
Well, yes and no. I mean, as we said in our bill, in our brief, and we really do invite you to read it, the problem with this is, with a lot of the other initiatives the minister has made, there were extensive consultations. And so there was a lot of thought that went into it, and a lot of discussion in the process. In this case, the backgrounder said that the minister asked his, there was a campaign promise made, but he asked his department to review and make recommendations. And it almost sounds like he got a wish list from within the department, from some sectors, saying, this is what I'd like to see, and he's done that. I don't know where it came from, but I do know that we weren't involved in the process. And so sometimes mechanisms, take some time to develop and to test and to toss around. That's what should be happening. So I'd prefer to see that. There are improvements. We've talked about a few very specific ones in there. You can't do conditional sentences. You shouldn't be barring people for merely committing or for foreign convictions without a right of appeal. Leave them with the right of appeal. If they're bad guys, expedite them. Get them through fast.
Thank you, Mr. Crane. Mr. Lamoureux.
Mr. Chair, I appreciate the presentations from all the witnesses. I did want to pick up on a point in regards to the bill as a whole, that we have believed that it is fundamentally flawed, and in fact it should never have passed second reading, that we need to go back to the drawing board. And just listening to, and specifically Mr. Green, in terms of what you're saying, with the idea of no consultations and so forth, that it reinforces that. And we were the only party that actually voted for it not to even come to the committee, because we believe it is so fundamentally flawed. I want to pick up on something that you had made reference to, and I talked about this on Monday, and I'm going to repeat it. And this is just a quote that I took from another presenter with regards to the Criminal Act, and it states, and I quote, "Using a false or a fraudulent document is an offense under S. 368 of the Criminal Code, carrying a maximum potential in a penalty of 10 years. A 20-year-old permanent resident who is convicted of using fake identification to get into a bar while visiting the U.S. is inadmissible under the IRPA for a foreign conviction. It doesn't matter that the U.S. court punishment him with a $200 fine. IRPA's S36 bracket 1B does not require any particular sentence, only a foreign conviction." And some would suggest to you that it doesn't even actually require that conviction. Now, using this in a real-life example, you get someone that maybe was born in another country, and then they come to Canada when they're 2 or 3 years old. They'd be in Canada for a number of years. When they're 19 years old, maybe they've graduated from high school, they cross the border. And they use false ID in order to get served alcohol, because there it's 20 or 21 in order to be served alcohol. They get caught, they're going to be deported. The rest of the family can stay, but they're going to be deported, even though they've been in Canada for all intents and purposes all of their natural life, coming at age 2 or 3. We're not talking about the exceptional case when the minister introduced the bill where he said, well, here's the 5 reasons why this bill is before us. And then as a result, and it was just one horrific story after another horrific story, and then labeled it the Foreign Criminals Act, faster removal of foreign criminals. Just, it's a scary message that I believe is sent to 1.5 million permanent residents that call Canada their home. My question to you is, do you believe that this bill would be better off for the minister to go back to the drawing board, consult with different stakeholders, and attempt to reintroduce a much more modified piece of legislation, that in fact it would be better to see that done as opposed to having to go through the charade of trying to come up with amendments to try to band-aid the legislation itself?
Yeah, it's probably not a charade, but it's a difficult exercise to try to fix it. I think it's fundamentally flawed, and we have recommended that it go back to the drawing board. We're prepared to work with the government. We recognize, as we said at the outset, it's so important to keep public faith in immigration. We don't want to happen what happened in the United States, which is where people have lost faith in the enforcement, and so they won't support meaningful immigration reform. Now, the minister has done some incredible things with modernizing and improving the system, but he can't do them without public support. And I know that's why he wants to do this kind of thing. But this is the wrong way to do it. And I think that I support that. In fact, focusing on these extreme cases, the egregious cases, can be counterproductive, I think, because it can make people think there's a bigger problem than there really is. A lot of the cases he cited are very old, and they're pre-IRPA. They're not even under this legislation. So it's a bit dangerous to do that, because you risk making people think that we have a big problem with immigration. We should just stop immigration. There was just a recent poll I saw that where there's been a shift, and a greater percentage of the population is concerned about immigration levels. And I'm wondering about whether the alarmism that comes in this kind of thing is contributing to that.
And, Mr. Chair, a very quick question to Mr. Pactican. I appreciate your comments, Reese, in regards to the misrepresentation. Can you cite maybe an example or two in terms of what you would think is an unintentional misrepresentation, just to add to it?
Well, Mr. Lamro, but beyond the unintentional misrepresentation, the big problem is the misrepresentation when a consultant does it without the knowledge of the applicant. There were a number of cases that were decided in the federal court recently where a misrepresentation was held, where a fake English language test result was put in by a consultant. Those people were found to have made a misrepresentation. Their applications were denied. Under the new legislation, that would generate a 5-year bar. That's not fair. The difference in some of these provisions is here is where innocent people can be penalized. And there is no right of appeal for these innocent people to be penalized. And if you take out this misrepresentation bar for the innocent, and you put it on to people who have really put in fake documents, knowingly put in fake documents to try to jimmy their way into this country, that's the people you should be taking out. But the law of misrepresentation, as Mr. Green has indicated, is broad, and it affects people who have, as Mr. Green has cited in the case, individuals who will not put them.
I'm sorry to interrupt you. Mr.
No,
Weston.
fair enough, Mr. Chair.
Mr. Weston.
Thank you, Chair. This has been an extraordinary day. I thank all of our witnesses today. You have presented yourselves clearly out of sincerity and balance, and it's hard to deny the credibility of a witness who's, on the one hand, finding problems with the Act, but complimenting the minister for other things that he has done. So in all cases, we thank you. I'm very proud to be in this committee and to share with my colleagues the process of opening Canada's doors to so many people from around the world. And our numbers really tell the story of 250,000 people coming, a very generous refugee system. And it's often said it's the immigrants themselves who are the most ardent in support of the kind of measures the minister is proposing here. So let me just put a very basic question to you. Is it not reasonable thing to ask that permanent residents not commit a serious crime in order to retain their permanent resident status or to obtain citizenship? Let me first go to you, Mr. Green, first.
Sure. Of course it's reasonable. We should expect that. We should. The only thing that I say is things aren't black and white, and our criminal justice system is a good example of that. We expect people to obey the law. If they don't obey the law, there's consequences. Now, the consequences depend on how serious the violation is, whether it's a one-off or whether it's a pattern. Same thing should apply to immigration. Now, a lot of people, and your average person, and a lot of I talk to people. I come from Calgary. You can imagine. I hear it all the time. Think it should be zero tolerance. But zero tolerance doesn't really work. Human beings are far more complex than that. When you get somebody who comes as an infant, it's a little bit, and they're here for 20, 30 years before this kind of thing happens, it's a little bit harder to apply zero tolerance to them.
Let me switch to you, Mr. Decan. The question is, isn't it reasonable to just expect of an immigrant not to commit a serious crime in order to retain his or her status or to obtain citizenship?
Absolutely. I mean, we all expect people to be law-abiding, and there are consequences for breaking the law. One of the things that is sometimes lost in this discussion is even though there may not be an immigration appeal for some of these individuals if they are convicted of a penalty of more than 6 months in jail or more than 6 months of incarceration, they have the ability to say, hey, look, I could be deported, I don't have an appeal, and take that into account when you sentence me. And the courts of appeal in Manitoba, the courts of appeal in Ontario, the courts of appeal in Nova Scotia, Northwest Territories, and other jurisdictions have said this is a consideration. And there have been cases, many cases, the case of Arganda in Manitoba more recently, where the courts of appeal have actually reduced a sentence to preserve a right of appeal. So the immigrant who commits the crime, the convicted criminal, has the ability to argue at their sentence when a judge, a criminal judge, a Court of Queen's Bench judge, can take into account the victim impact statement, can take into account the issues of all of the things that they should be taking into account in sentencing, and also the particular circumstances of the individual. And when you take into account all of those things, that is essentially what the immigration appeal does. And so it's not that we're taking away the right to state what a circumstance of the individual criminal is. They can do that, and the courts of appeal have recognized that.
Something that shocked me was that there are some 850 people who, on an annual basis each year, are making appeal to the IAD in order to delay their deportation. So it's not just a question of individual cases where we've put some focus in the testimony today, but the volume. Mr. Packard, what do you think of that number? Does that surprise you, or is that a significant number in your mind?
Well, there's lots of people who commit crimes. 850 might not be a significant number. I'm not too sure what the volume is in terms of other cases. I'm not too sure that that's an alarm bell in terms of the number that are appealing. And I haven't seen the statistics as to what that number would be if you reduced it to the 6 months from the 2 years less a day.
Okay, well, good comment. The other issue that concerns me is in terms of people who are inadmissible on very serious grounds, such as war criminals, human rights violators, and organized criminals, people who have been able to delay their deportation applying on the humanitarian and compassionate grounds. Can I get your comment on that, Mr. Pagdakan? What do you think of the C-43 provisions that will take away the humanitarian and compassionate grounds of delay, to delay a deportation for somebody?
Well, for those types of crimes, those things are, I don't want to say that some crimes are more serious than others, but those are really up there on the level of seriousness. And to take away an appeal on humanitarian compassionate considerations on that, that's a very big thing you're taking away. But if you're going to take it away from anyone, you take it away from war criminals, you take it away from those terrorists, you take it away from those types of people, because the nature of that crime is something that you would say, well, what humanitarian ground are you really going to say? Here's the humanitarian ground. I blew up a whole bunch of people, but this is a really good reason why I should stay. I'm having trouble figuring out what that humanitarian ground would be.
And I guess I would put this to both of our witnesses, as a fellow lawyer and as someone who cares about due process and who's argued these humanitarian compassionate things in other arenas before, I want to maintain the confidence in our immigration system, the confidence that we are bringing in good people so that all Canadians can support a minister who wants to continue to bring in such an enormous number of people each year, confident that we're bringing in good people that are building the country and not alarming the country. Any last comment, Mr. Green?
Just on the War Criminal Fund, the thing I'd point out there are shades of gray. It sounds like it's egregious. Yeah, if somebody's been blowing people up, there's no question. We don't want them, and we should get them out fast or keep them out in the first place. But
we have to move on. I'm sorry.
Okay, I'll just say Nelson Mandela would not have a right of appeal under this legislation. And just to use an extreme, but I'm going to throw you back a reverse. Sorry?
Sitsa Bayisan has the floor.
Thank you, Mr. Chair. Thank you to our witnesses who are here as well with us today. We agree that non-citizens who commit serious crimes in Canada should be dealt with quickly. However, we're very concerned that this Conservative bill will concentrate more arbitrary power in the hands of the minister without checks and balances. And I was reading through your briefing to the committee, and I see that you feel similarly, Mr. Green. So what are the implications of an enormous transfer of discretionary power from the judiciary to the political office of the Minister of Immigration as proposed under this bill?
The CBA's, and by the way, it's not my personal views. I'm presenting the Canadian Bar Association's views, and this was quite a fairly extensive consultation went into this amongst the bar. But in any event, we have been concerned about this in a number of pieces of legislation. Just so you know, that the review process will still happen. The review of the relevant factors. It happens now with people who get more than a 2-year sentence. It happens by an officer, and the problem with it is it's difficult for officers to make these decisions because nobody wants to put their career on the line and make a bad decision. Whereas an independent judicial, that's their job. So somebody who's a board member has to do that. They have to weigh the factors. Whereas an officer, it would be a career-limiting move to let somebody stay and then have that person reoffend. So we just think it's a bad idea to transfer those powers. That's why they created the Immigration Appeal Board in the first place in the 1970s, was to take that away from officers and to create an actual more effective system. And I think most people work in the system think it is effective. I think the real problem people are concerned about is just delays because we have a volume. 850 a year. I don't know if that's a huge volume, but we have, that causes the system to back up, especially if it's not resourced.
Thank you. So the minister has underlined half a dozen cases of extreme repeat non-citizen criminals who have gone on to repeatedly commit serious crimes by delaying their deportation. We've mentioned a couple of these cases here today already, and clearly many of these sensational cases show serious problems with border security. We need to stop criminals and terrorists before they arrive in Canada. However, conservative cuts with border services will mean that Canadian officials will have to try to do their best, of course, now with less. So is removing the right to an appeal really the only way these cases could have been prevented? I'm going to ask you a few questions and then give you the rest of my time to answer them. Removing the right to appeal, is that the only way to prevent these cases? Do you have any suggestions on how Canadian Border Services might be better equipped to prevent serious criminals from entering Canada in the first place? And I just asked you the same question twice. And how do the cuts to CBSA impede these efforts? The rest of my time is yours.
Well, I don't think we have a problem with preventing serious criminals from coming here. I don't think that none of the examples, at least that I've seen, have been that the minister's given involves somebody who got in who shouldn't have got in. It's all people who've committed offenses after they got here. I think the tools are already there. Plus, they're improving with biometrics, and it's going to be much harder for people to adopt a false name. Somebody who's been deported, say, and a false ID and come back because the minister's bringing in some other proposals to make it more effective. I think, and I've already commented about this enough, I think that made the point that you can do triage. You can have the officers impose conditions on the less serious offenses, so you save the more serious ones to go to full hearings.
1 minute.
Sorry, I keep messing with the mic. Okay, so I'm going to follow up with similar vein here. So we've heard from Auditors General reports time and time again about the lack of resources, the not having adequate training for CBSA and not having adequate integration of CBSA and CIC staff. Do you think that we should be investing more time in ensuring that our existing legislation, which I believe earlier you mentioned is adequate to achieve the goals that are being said are the goals of this legislation, should we be investing in making sure that our existing legislation is actually being enforced rather than just writing new legislation?
Well, I'm going to leave some of that to the political realm, but I'll just say that I don't think the problem I don't think the legislation is going to really solve the problem. Changing the legislation, there's still going to be the problem, because what happens now is somebody who's ordered deported who doesn't have a right of appeal, we still go through this process, the same process of gathering information and presenting it. We just do it in writing. Then it goes off to an officer downtown Calgary, in my case, and then off to Ottawa. And the process takes many, many months. And I've seen those things stretch out for years, and inexplicably to me sometimes. But I know what it is. They're just stretched a little thin in resources. Again, I say it's priorities.
Thank you. Contrary to what I said, I understand the bells are now going to ring at 5:45. So we will adjust and proceed as usual. So this session will end at 4:30. Mr. Menengakis.
Thank you, Mr. Chair, and I too want to thank our witnesses for appearing before us today. Certainly finding your testimony very interesting. A couple of statistics. Last year, 43 million people visited Canada's immigration website. A record 265,000 new Canadians, new people were accepted, immigrants into the country. A record since the Second World War, something that is going to be repeated again this year. Surely in that number of people interested in coming to Canada, come to Canada, there are law-abiding citizens that should have the priority of coming here over those that would break our laws and commit crimes. Ms. Sims referred to the Clinton Gale case as a sensational case. I would agree with her. It is very sensational. Todd Bayless, at 24 years of age, was gunned down. He was murdered by a serial killer, a drug dealer, while in his duties as a police officer, he was trying to disrupt a crack cocaine drug deal. Clinton Gale was still in Canada because he had appealed to the Immigration Appeal Division, the IAD. Mr. Pagdakan, my first question is for you, sir. Do you agree with the ability of criminals like Clinton Gale, serial criminals, I would say, convicted of serious crimes like drug dealing several times, do you agree that they should have the right to an appeal?
No, because they have the right to discuss these issues at sentencing. The courts of appeal, this was a case in Ontario, the Court of Appeal of Ontario has said that. If he could convince the Court of Appeal to give him a sentence that is under the amount that would allow him to appeal at the Immigration Appeal Division, then so be it. Let the sentencing judge make the decision on this. The sentencing judge has the ability and is hearing the evidence of the actual crime. Here's the evidence of the police officers. Here's the evidence of the witnesses. Here's the evidence of the victims. And also at sentencing can hear the argument of counsel for the defense. And that is where the protection is for the accused, who, by the way, by the time that they are going to be sentenced, are now the convicted. But that is where the protection lies. And there is no necessity for an additional appeal if that protection is already there, as set out in this case, the Ontario Court of Appeal.
I've heard several witnesses over the last few days that we've been debating this legislation, doing this study here on C-43, referred to the issue of permanent residence and some people that may come here at 2 years of age but, decide they're going to enter criminal life at age 30, and should they be treated as a foreign criminal or a local, if you will, a Canadian citizen. Clearly, in my opinion, there is a difference between a permanent resident and a Canadian citizen, and clearly, if you're old enough to commit those crimes, you should know what some of the benefits of Canadian citizenship are, and you've had plenty of opportunity in your lifetime to attain that. However, I'm going to leave that aside for now, Mr. Pagdacan, and I'm going to ask you this question. The Canadian Association of Chiefs of Police and the Canadian Police Association have come out strongly in support of Bill C-43, saying that it will make Canadians, including the vast majority of immigrants in Canada, who are honest and law-abiding, much safer. Do you agree or disagree with the views of these police organizations?
On the issue of the taking away the right of appeal for people that have been convicted of a crime of 6 months or more, I'll answer yes. You've heard my testimony on some of the other issues where I have concerns. And I agree, Mr. Menenjakis, with your assessment. These individuals have made a decision to commit a crime. You have to have what we lawyers call actus reus and mens rea to commit a crime. These people have made that decision. They are criminals. They are not the accused. They are not presumed innocent anymore. And when you make that decision, you have to face the consequences.
Thank you very much.
Thank you, Mr. Menenjakis. Mr. Lung, you are the final speaker.
Thank you, Chair, and thank you to the witnesses for appearing. Let me say that in my life I've lived apparently in Taiwan and Japan and Canada. And when I came to Canada as an international student, it was quite clear to me that I value the systems of law and order and good governance here, and that the fear of not completing my studies, the fear of not running afoul of the law was a heavy burden to hang over me, and also just to be a good citizen in this country. Now, I find it difficult to fathom that as lawyers, evaluating the legal system as legislatures, that we allow this type of discussion to go on to indicate that why are we allowing people to come in here that have a disrespect for our legal system or disrespect for our law? Mr. Pagdacan, I wish to hear from you that, is it too much to ask of people who come to this country not to respect and obey our laws? And if not, why do we get ourselves wrapped up in this type of discussion? Perhaps you can address that. Give us your thoughts on that.
I don't know why we necessarily get wrapped up in these discussions, although these are important discussions, and the committee will have important things to say, as do citizens and my colleague, Mr. Green of the Canadian Bar Association. But in answer to your first question, it is not too much to expect an individual who immigrates to Canada to respect the law. Frankly, it is not too much to expect Canadian-born individuals such as myself to respect the law. We expect people to respect the law. That is why we have a criminal justice system. People who break the law face consequences, and individuals who have chosen not to get Canadian citizenship or have not been here long enough to obtain Canadian citizenship will have other consequences that will befall on them. Every individual, as every lawyer knows, every judge knows, is presumed to know the law. And if you are presumed to know the law, then you better be on the right side of it. Otherwise, face the consequences.
And that also includes people who came here at a young age, so therefore the ignorance of the law is not necessarily an excuse to say that he has a right to stay here because he grew up here all his life and therefore have no attachment to his where country of origin that he came from.
Well, Mr. Lung, the issue of the people who have come here that are younger, I mean, clearly there's a bit more sympathy for those individuals, but we're not talking about anyone who has been convicted of a crime. We are talking about an individual who has been convicted of a crime and sentenced to a period of incarceration of at least 6 months. We're not talking about, someone who's got pulled over for reckless driving. We're talking about someone who has been sentenced to jail. That is serious. In the guidelines that the criminal code has is judges should avoid giving people jail if that's the way it should be. These people are being given jail by judges who have heard these cases and have made a decision on the sentence. That's where the difference is. If we were talking about deporting everyone who was convicted of shoplifting one time, I would have a real problem with this. But that's not what we're talking about here, Mr. Long.
That's right. So in my understanding, C-43 or this particular bill really addresses serious criminality. And that
provision.
Okay. Mr. Chair, I guess my time's up. Thank you. Thank you, Mr.
Mr. Paglican, Mr. Green, Ms. Frock, thank you for your contribution to the committee. I know we will take comments under advisement. Thank you very much for appearing with us. We will suspend. Okay, we'll reconvene. And just to have some order, please. This meeting will end at 5:25, and then the committee will go into camera to discuss committee business. Our final witness is one. Table de concentration des organismes de service des personnes réfugiées et immigrants, Riffiga Ogunfield, representative, and Richard Goldman, Refugee Protection Coordinator. You've both been here before on C31, and we thank you for appearing before us again to give us your views on C43. And between the two of you, you have up to 10 minutes to make a presentation to the committee. Thank you.
Merci beaucoup, Monsieur le Président, et merci.
Thank you very much, Mr. Chairman, and thank you for the committee for having invited us to appear today. I'll begin in French, and then my colleague will continue our presentation in English. So I'd just like to let you know that the Table de Concertation des Organismes, the TCRI, is an umbrella group that has existed since 1979. So it was created when the boat people arrived. I think probably everyone above a certain age here is familiar with this. And our organizations exist throughout Quebec. They advocate for refugees and immigrants across the province, especially those outside Montreal. They assist with government-assisted refugees, etc. Organizations also work with asylum seekers, and that work is usually done on a charitable basis. There is no government that funds this kind of activity. Today, we're here. We have already appeared before you. We're here to speak to you about what's happening on the ground. And we're here to speak to you beyond labels, beyond abstractions.
Goldman. I just would like to say that Rick Goldman is a lawyer. He works for the Committee to Aid Refugees, which is a not-for-profit organization. He does not do private practice cases, so everything we're saying is coming from a community point of view. And some of the things we'll be discussing today, I hope you will hear with the ear of members of Parliament with constituencies, and I'm sure every one of you has had in the past or recently cases where people come to you with problems where you say, oh, this isn't quite like what I thought a so-called security risk looked like or what a so-called person with a criminal past looks like, that there are human beings in front of you, and when you meet them and when you talk to them, you realize that life as people have lived it is often not quite the way it looks on paper. So I will now hand over to my colleague, and we will be mostly addressing the brief that you have received.
Thank you. Thanks again for your invitation. We're very happy to be here. We're going to focus on one area of particular concern under Bill C-43, the denial of access to humanitarian and compassionate, or H&C considerations to persons excluded from refugee protection, and the denial of H&C considerations to persons found inadmissible on security grounds who apply for ministerial relief from such inadmissibility. And we'll start with a real-world example of a person who's being currently assisted by one of our member organizations. So this is Salma's story. While still a student in her civil war-torn country in Latin America, Salma was recruited into the student arm of the opposition movement. She helped run meetings, sometimes serving coffee and taking minutes, and was involved in organizing peaceful demonstration. Years later, after peace accords were signed and the movement became a legal political party, she again volunteered during an election campaign. Salma says she inadvertently came across evidence of illegal activities and was targeted by party officials who first threatened and then brutally assaulted her. She fled to Canada to seek asylum. However, the Immigration and Refugee Board found that her involvement in the movement, which had a guerrilla arm that had targeted some civilians during the Civil War, excluded her from being considered for refugee protection in Canada, and she was deemed to be complicit in crimes against humanity. In addition, even though an official at Canada Border Services Agency confirmed that Salma had never been involved in any act of violence and posed no danger to Canada, by automatic effect of the law, she also became inadmissible for permanent residence under Section 35 of IRPA. Canadian medical professionals believe that Salma was indeed the victim of sexual assault and that a return to her country would be extremely destructive to her mental health. She has no family to return to back home. Her only son and her ex-spouse have immigrated to Canada in separate immigration procedures. Now, under the law as it stands today, Selma can still apply for permanent residence on humanitarian and compassionate grounds. In examining such an application, an officer would have to weigh the factors present, the hardship for Selma of returning to the country of her traumatization, her medical situation, the best interests of any child affected, the link she has developed to Canada, and, of course, the nature of her activities with the organization with which she was associated. The officer could then decide whether to grant Selma permanent residence on H&C grounds, including a waiver from her inadmissibility. However, Bill C-43 would render this impossible. She could not even make an H&C application. And in the previous presentation, I heard it referred to as people making H&C applications to delay their removal from Canada. Just to be completely clear on this, an H&C application does not delay somebody's removal from Canada. Now, this is a matter of great concern to us. It's our experience that Selma's case is not an isolated one. Rather, it's our experience that the exclusion clauses are being applied by the IRB in an increasingly broad manner, and our experience is corroborated by a comprehensive academic study which decries the growing culture of exclusion in Canada. This study, which is cited fully in our brief, was published in 2011. It examined every exclusion case made public during the period of 1998 to 2008. And here are some of the conclusions. Exclusions at the IRB have increased dramatically during this period, from 2 cases in 1998 to a high of 114 in 2004 and 79 in 2008. The Canadian government has aggressively pursued exclusion by intervening in IRB cases, and it has employed, quote-unquote, creative arguments at all levels of adjudication. On the issue of complicity, the cases reveal a troubling state of affairs. It is who you are or who you are associated with, rather than what you have done, that often provides the basis for exclusion. Further, these understandings of complicity go beyond the findings of international criminal tribunals, which only dealt with the persons most responsible for international crimes. In this way, refugee law is being used to assign culpability at a far lower threshold than international criminal law. And finally, the authors, who are 2 academics from UBC, conclude, this fails to conform to the humanitarian requirements of international refugee law and to international human rights law, and it ignores the fact that many of the excluded claimants have never participated in violence or specific crimes and would not have been excluded a decade ago. So that's the first part of our main concern. Now, the second part is eliminating H&C considerations from applications for ministerial relief. We sometimes see people whose stories are very similar to the one I just told you, but who are caught by the inadmissibility provisions in a different way. For example, even if the IRB had chosen not to exclude Selma and had granted her refugee status, she could have subsequently found herself declared inadmissible to Canada under Section 34 of IRPA for having been a member of an organization that there are reasonable grounds to believe has engaged in instigating the subversion of force of any government. I don't think I'm the first person to tell you this, but has frequently been observed. Even Nelson Mandela, were he not an honorary Canadian citizen, would fit this definition. Under the law as it stands today, such persons can apply for ministerial relief from their inadmissibility. To succeed, they must satisfy the minister that their presence in Canada would not be detrimental to the national interest. Historically, the minister has taken H&C considerations, such as the ones I was talking about earlier, into account in examining such requests. However, Bill C-43 would amend the relevant section to read that the minister may only take into account national security and public safety considerations, but in his or her analysis is not limited to considering the danger that the foreign national presents to the public or the security of Canada. And under the same provision of Bill C-43 that I talked about with Selma's case, Such persons are also barred from filing applications for permanent residence on H&C grounds. So they're barred either from asking for ministerial relief on humanitarian grounds or applying for permanent residence on humanitarian grounds. We believe that this complete exclusion of H&C considerations in these contexts is contrary to Canada's international obligations under the International Covenant on Civil and Political Rights, which, among other things, provides protections of family rights and security of the person. We believe it also violates Canada's obligations under the Convention on the Rights of the Child, since it would eliminate consideration of the best interests of the child, which is normally an important part of H&C decision-making. It would also violate our obligations under the Convention eliminating all forms of discrimination against women, the CEDAW, which protects women against gender-based discrimination.
Perhaps you could wind up, Mr. Goldman, please.
Okay. So our recommendations that Section 9 and 10 of Bill C-43 should be amended to ensure that persons excluded from refugee protection are nonetheless permitted to file H&C applications and have them fully considered. And Section 18 of Bill C-43 should be amended to eliminate any restrictions on the factors the minister may consider in examining requests for ministerial relief. Thank you.
Thank you very much. Mr. Weston has the floor.
Okay. Merci, Mr. Président.
Thank you, Mr. Chairman, and thank you to our witnesses for coming today. I think that everyone around this table would agree that Canada probably has the most generous approach in the world in terms of our immigrant and refugee policy. However, if there's an action that takes place, there has to be a reaction. And we have to think about how we can preserve our generous policy. How can we sustain this, and how can we continue to allow 260,000 immigrants to come in every year to Canada? How can we continue to welcome refugees in numbers that are perhaps the most generous in the world? So I put this question to you. When one is considering those with permanent residency status, is it reasonable to suggest that they not commit serious offenses here in Canada as a condition to preserving their status? And is it reasonable to expect that they should have to retain the trust of Canadians and other refugees who are coming here to Canada?
All our member organizations agree that it is not too much to expect foreign nationals, just like Canadian citizens, to obey the law. The question is, we absolutely agree that where there's an action, there should be a reaction. The question is one of proportionality, one of degree. I think everyone here agrees that foreign criminals should be removed from Canada as quickly as possible. Our concern is that this new definition of serious criminality has lowered the threshold alarmingly. If the 18-year-old kid who lives next door to you breaks into your house and drinks some of your liquor, you'd probably want to have him punished. You'd probably want to give him maybe even a kick in the behind, but you probably shouldn't be taking the law into your own hands. But if he came from Iran or Eritrea at age 3, he has no family back home, he doesn't speak the language, he doesn't read or write the language, I think most Canadians would agree that there should be some weighing of the humanitarian considerations as to whether he should be deported from Canada.
Monsieur Goldman, est-ce que je peux vous interrompre?
Yes, but Mr. Goldman, allow me to interrupt you. Under the criminal process as it stands, this individual has all the rights under the Charter. There's a presumption of innocence. And that individual can also plead his case on the grounds of the consequences of a conviction. So Canada actually provides many grounds for defense for these individuals. And if crimes are committed by those individuals and they are not deported, I fear then that Canadians will lose their trust in the system. And the most serious consequence then is that the minister cannot continue to sustain that generous policy. What would you say to that? Perhaps to respond to that question, not to cut off my colleague here, but to respond to that question, yes. However, the problem is that if the legislation is amended in order to capture those serious criminals that you're referring to, it will also end up capturing the types of individuals that Mr. Goldman is describing. So it's too broad a scope. It's too big a hammer, a sledgehammer, to deal with those very serious criminals. Everyone agrees that we don't want serious criminals. I absolutely agree that we don't want people who are guilty of war crimes.
Relief, people that you did not intend. I don't think you would intend that this Salma be not granted some kind of relief. She didn't do anything. She didn't do anything. She is not a criminal. So why are we punishing her in the same way that we're punishing someone who committed terrible crimes against humanity? We have to have a way, as you said here in Canada, where we do apply the law and we are generous, to make a distinction and to have measures of relief that can help a Salma while not, giving years and years and years to some grave criminal who committed crimes against humanity.
En plus de Salma, j'étais choqué qu'il y a...
Yes, but I was shocked to hear that 850 individuals per year use humanitarian grounds as a way of delaying the process. What would you say to that?
To your exact question, which was about the criminal justice system, it's my understanding from reading Court of Appeal jurisprudence from different provinces, including Alberta and Quebec, that the courts are not seeing it that way in terms of being able to present immigration arguments at the sentencing stage. I'm not the world's greatest expert on criminal law, but I don't believe it's settled that across Canada you can make immigration-related arguments when it comes to sentencing.
Clearly by our previous witness, actually, Mr. Goldman.
Well, that's not my understanding. I'll leave it to the criminal law experts, and I would say that before the government goes ahead with a provision that would remove humanitarian discretion, you should make absolutely sure that this argument can be made in criminal courts across Canada. It's not my understanding that it can.
I'm sorry.
We're confident.
We could go on, but our time has expired. Madame Gregouet.
Merci, Monsieur le Président.
Ms. Gregouet, thank you. And I'd like to thank the witnesses for coming today. And I'd also like to congratulate them on the quality of their briefs, on all the briefs that were presented today, those that were put forward by the bar and these witnesses, and the fact that they draw our attention to any concerns, serious concerns that this Bill C-43 presents. We feel that civilian society and ourselves, as representatives of that civilian society, need to ensure that our legislation is fair and compliant, not only with the Canadian Charter, but also with, as you mentioned, the commitments that we made when we signed certain international treaties. Mr. Goldman, in your opening remarks, you raised your concerns about what you called this exclusion culture in Canada. And more specifically, you spoke about the exclusion of asylum seekers under those who are refugees under the Convention Geneva, and that they wouldn't be able to use humanitarian grounds, even when a CBSA officers state that they never participate in criminal activities and they don't represent any danger for Canada. But under Bill C-43, they would have to be deported, even if that means they may be exposed to torture. So then why do you think this is so? And what kind of recommendations could you make to that concern? Thank you very much. I think it's perhaps going a bit far to say that they may be deported even if they're going to be at risk of torture. Because under the Convention Against Torture, Canada actually is committed to not deporting those individuals. However, if you do not look at the risks before, however, I would say that's being kept for those who are excluded. Perhaps I would say that it's going a bit far to say that they can be deported if they will be at risk of torture. However, they will not be able to put in an application for permanent residency on compassionate grounds. Now, as to what we said in our brief, there are, yes, situations where individuals have not participated in criminal activities. And we do have a recommendation that is not very complicated, and that is that it not be amended to eliminate any restrictions. So when you're using humanitarian grounds, to say that that can delay your deportation is not true. There is no suspension of deportation, and so it does not guarantee that you are going to be accepted. An immigration officer sits down, weighs all the factors, weighs the difficulties, medical, for example, factors, any dependents that may be affected, any children that may be affected. So our recommendation is not complicated. Immigration officers should be allowed to continue to do their work the way they always have done, and they need to be able to decide on these applications. And at risk of repeating myself, there is no suspension of deportation in these cases. Thank you. So you spoke to this increase in exclusion, and you said that there would be too broad an interpretation in Canada. So what kind of problems does that raise, especially with respect to international protection? Well, it's very clear to us. When you look at the numbers, there were 2 cases in 1998, and there were about 80 cases per year. Obviously, that is increasing, and I would recommend that you read the study by these 2 academics from UBC. They actually considered several situations of individuals who never committed any sort of violent activity. They participated unawares in movements early on, like Selma did. Because any person who's denied protection that they need is then potentially someone who can be eventually persecuted. Thank you. A previous witness spoke about the need for much broader and extensive consultation on Bill C-43. And they also said that Bill C-43 was casting much too wide a net. One of the witnesses stated that there should be some sort of triage process in terms of crimes committed and criminals. What would you say? Yes, I absolutely agree. Now, I know that we're not here to speak to refugee status determination. However, sometimes it can take 40 months or 50 months to send back an asylum seeker. In my personal experience, and in the experience of our member groups, oftentimes we were waiting for 15 months just to be called. The same thing happens for those who have committed crimes. The CBSA can do this sort of triage work in order to prioritize cases. Earlier, we referred to sensational cases. Now, it seems to me in all those sensational cases, they would already have been covered by this 2-year bar. There's already this 2-year threshold. So deals with the serial type killers, there was no appeal. They had a sentence of more than 2 years. So we're concerned with the fact that the threshold is being set very, very low. I gave one example of someone, for example, who breaks into their neighbor's house. Well, under Section 345 of the Criminal Code, breaking in to commit a robbery can be punishable by life in prison. Now, say you're in a shopping center and you steal DVDs, you can end up for 10 years in prison. Now, if you have a 6-month sentence, we're saying there are no humanitarian considerations here. I think everyone agrees that serious criminals have to be deported as quickly as possible. However, the question is, what is serious criminality? We feel the cases that Rivka raised, for example, are not necessarily those serious criminality cases.
Thank you, Mr. Chair. I appreciate the comments from both witnesses. I want to pick up on the whole issue of humanitarian and compassionate grounds, and really what we're saying, and Salma's story is a very compelling story, I must say, and then you just finished citing a couple other examples. I think it's worth us emphasizing that all we're saying is that we should allow for that consideration to be given. That's really what we're talking about. We're not saying allow them to stay. We're saying allow them to have that opportunity for compassionate and humanitarian grounds. Correct?
That's correct. Absolutely. In both, we're talking about two very different situations in our brief. One is people who are asking for refugee status and who are excluded under what we feel are overly broad exclusion provisions. We feel they should have access to humanitarian considerations. We're presenting you a real-world case to show, I heard in the previous presentation, war criminals, we have to get rid of them right away. Somebody like Salma, who distributed pencils and coffee at meetings, has been labeled as a war criminal. That's one situation. We feel maybe she won't be able to stay, but she should at least have the chance to have her humanitarian case considered. The second case, kid next door breaks into your house, drinks some of your liquor, gets a 6-month sentence. We feel, and hasn't lived in Eritrea or Iran since he was 3, we feel he also should have access to a humanitarian appeal. Doesn't mean he'll end up staying in Canada.
And that's where I want to pick up on that particular example. We have 1.5 million plus permanent residents, and that's where this bill is actually going to have a very profound potential impact on the lives of many of these people that call Canada their home. Thousands of those people came here as young children. And is there not any sort of societal responsibility when you're here at age 3 and you commit somewhat of a crime, even if it's a minor crime, that there is a responsibility for us to take responsibility for that young person. In other words, should young people, if you're 8 years old, be exempt at the very least from this legislation?
I would argue that one really would have to look at this. There has to be some discretion to be able to look exactly at the humanitarian considerations. I would submit to you that some children who came here very young do not know that they are not citizens because it's their parents for whatever reason that didn't get them citizenship, and now it's a little late. It's not that they didn't do anything. They did certain acts, but are the acts worthy of getting them sent back to a country where they know nobody? And it also means that there is no chance of rehabilitation. One of the things that we've been told by some of our friends who are experts in penal stuff and rehabilitation is that if you take a young person and put them in jail and they know that at the end of the day they'll be deported, where does that leave them in terms of their enthusiasm for rehabilitation when in fact proper rehabilitation could put them on the right road, and they are barred from citizenship because their parents never thought it was important. It's not their fault. On the other hand, when we try and look at some of these other cases that we've been describing, we're looking at people who never committed any crime. They didn't commit a crime. And I think it's very easy for us sitting here to sometimes, and I include myself, to make judgments about people what people should have done or would have done somewhere in a country where there's a dictatorship, where there is repression, where there's oppression, persecution, and torture, and what people sometimes do faced with that as young people, and then to come here and then be faced with the fact that they are doubly and triply victimized because of an association with other people who might have been doing things that this person was not aware of. So this person, and this Salma is not alone. You know, we're using an example, but please, in the same way that sometimes examples from 20 years ago are used to justify things that we're doing now, this is not an isolated case. There are others. It's a particularly compelling one. There are others, and we see them. And what we're pleading for is the discretion to allow the person's circumstances to be considered and not have her barred from this consideration so that no matter what might happen to her as a result of getting returned, we're not going to be responsible if she's returned to torture, if she's returned to mental, to a total breakdown or whatever else might happen to her.
I'm sorry, Mr. Lamoureux. Mr. Dijkstra.
I'm kind of intrigued by your example. I suppose we're all using them to make our points here on the bill, and I appreciate that. I think we have all of us have the ability to do that and should be allowed to use examples to describe and explain what we're talking about. But Selma, the person who you're talking about, which is not her real name, but I understand you need to protect her. She wasn't a permanent resident. She was applying for refugee status. So I'm trying to see how you're relating a case that you could have presented under C-31 when we did our hearings on C-31, but I'm not sure why you're presenting a case of a refugee on a bill, C-43, which specifically deals with those who already have permanent residency. She doesn't have permanent residency. If she was coming from a foreign country and is applying to come to Canada, and if she had been convicted in her own country or charged and it believed to be true, she would not be admissible in Canada, but she could actually go to the federal court to try that. She could also apply under H&C because she actually isn't in the country yet. So I'm not sure why you're confusing or bringing this case in. Well, she's applying for refugee status, so she's not a person who falls under this piece of legislation. She would fall under C-31.
She does. This legislation does many things, and one of the things it does is take away the right to apply on H&C grounds for permanent residence of people who are excluded under 35. When, as it's explained in our brief, by being excluded from refugee protection under Article 1F, she's automatically excluded under Section 35. So the reason we didn't raise that, no, I mean, our citations are there, the sections of the law are there, it's all there. So the reason that we didn't raise this when we came on C-31 was because C-31 didn't take away the right of people like Selma to apply on H&C grounds.
Well,
this piece of legislation under Sections 9 and 10 of Bill C-43 does take away her right to apply for permanent residence on H&C grounds. That's why.
You're making my argument for me that she actually then has the opportunity under C-31 to apply for H&C.
No, this takes that right away.
Aside from our differences of opinion on this, you haven't commented on the new section 42.1, which actually would allow her to apply. The minister may, on application by a foreign national, declare that the matters referred to in Section 34, paragraphs 35, 1, B, and C, and subsection 37.1 do not constitute inadmissibility in respect of the foreign national if they satisfy the minister that it is not contrary to the national interest. So there is the opportunity, and this is what I find interesting about the dynamic in terms of negative discretion, which seems to get brought forward on a regular basis, but I never hear from those who are opposed to negative discretion, I never hear any comments about Section 42.1, Section 42.1, and Section 42 in parentheses 2, and then in parentheses 3, which actually didn't exist do not exist in the existing legislation, but do under the proposed legislation. So I'm assuming that if you were not in favor of the whole aspect of negative discretion, that you would therefore not be in support of the new piece which adds positive discretion to allow the minister, if he or she sees fit at public safety, to actually allow the individual to stay in the country.
Okay, please read very carefully the sections that we cite at footnote 5. She is caught by section 35(1)(a), so the sections that you just mentioned does not apply to 35(1)(a). She cannot ask for ministerial relief. Persons who are excluded from refugee protection under section 1FA of the Convention and therefore inadmissible on 35(1)(a) have never been able to apply for ministerial relief. But they have been able to apply for permanent residence on humanitarian grounds. Bill C-43 under sections 8 and 9 is taking that away. We didn't talk about it under C-31. C-31 didn't take it away. C-43 is proposing to take it away. Now, moving to the...
Sir, I don't just hold on a sec. The chair always wants to give people the time to respond to questions, and I want to do the same. But we have 7 minutes, and it cuts into the area that I'd like to go. And I know this isn't an easy dialogue to have because it's technical. But the fact is, the example that you cite is someone who actually was refused refugee status. She didn't qualify for refugee status. So you're making the leap, like the examples that we bring up are of convicted individuals that have gone through court and been convicted of a crime. You're speaking about, and you want to use like a very, very small area that you want to concentrate on, where an individual actually was not given refugee status. You may have your opinion as to whether or not the IRB made a correct or incorrect decision. I respect that. But you can't use a decision that was denied to suggest that this individual now has been denied something else when they actually don't have refugee status to begin with.
The reason she was denied refugee status is, as we explained, because of a very low-level involvement in a multifaceted opposition movement, which we
agree with the decision, but the decision was not to allow the individual into the country based on her application. Sorry, not to allow her refugee status based on the...
Let's agree let's agree with what you said so far. The point that we're making is that person with her profile was at least allowed to make a humanitarian application and is still today allowed, but would not be if Bill C-43 is adopted.
Because she isn't a true refugee.
Sorry?
Because she's not a true refugee. She was denied. Her application was denied. Therefore, the rules fall into place, and that is, the rules are the rules, and they need to be followed. Just because you don't happen to like the rule doesn't mean that it isn't one that actually has been judged to be. Would you say the IRB is not a quasi-judicial and fair board? Are you suggesting?
I don't understand why you're saying because you don't like the rules, those are the rules. We're talking about a change in the rules. We're talking about Bill C-43 changing the rules so that someone like Selma can't apply on humanitarian grounds. That's what we're talking about.
I have to say time, unfortunately. Ms. Freeman.
Thank you, Chair, and thanks to our witnesses for coming to present to our committee today. The more we hear about C-43, it seems that we're not only creating legislation that's going to affect criminals, but also, which is supposed to be the intention. I mean, we asked the minister about it, and that was the intention. It's supposed to affect serious criminals. We need to get them out of our country faster. But it's also, we're seeing that it may be affecting victims or creating victims. Could you speak to how other examples, other types of examples where victims may be created due to these changes, or victims may be kept out of the country due to these changes in C-43?
Well, I'm going to ask my colleague for help. There was a case recently in Montreal where a very seriously mentally disturbed man was killed in an altercation with the police. He was an Iranian refugee. He had been recognized as a refugee, but he was not. I don't think he was a citizen yet. No, he was not. He was a permanent. But he was because he was disturbed. He had he ended up walking into a building looking for shelter. He was a homeless person. Even though he couldn't have been deported, the CBSA started deportation proceedings against him, and the starting of these deportation proceedings against him put him over the edge and scared him so badly that he ended up having a psychotic breakdown. And I will turn it over to my colleague to just explain what the implications are there.
In other words, this was a case where, although it was just a breaking and entering, he received a sentence. It's a crime that is punishable by 10 years or more. So although he was a refugee, it was extremely unlikely that he could be deported because he didn't seem to be a danger to the public and, in fact, had mental health problems. CBSA chose to take deportation proceedings against him just to get the deportation order on the file. This actually sent him over the edge and led to a fatal altercation with the police. So we do think it's an example of where overzealousness can lead to a very adverse consequence for somebody.
I'd like to know. So les fausses déclarations. On a eu des.
So in terms of misrepresentation, we heard witnesses that told us that sometimes there can be unintended misrepresentation. Could you speak about any recommendations in that regard? Yes, it's very clear to us that there can be unintentional misrepresentation. It might be because of a consultant. It might even be because of a family member. And it might even take place in some humanitarian circumstances. I'll give you a concrete example of one young woman from the Congo who had been raped in her country at the age of 14 years, and she did not declare that she had a child. Her parents were accepted on refugee status accepted on family reunification, but she did not want to declare the fact that she had borne a child because of that rape. So she was caught under that regulation 117.9D. Now, an application for sponsorship on humanitarian conditions was made. But you see, sometimes there can be misrepresentation for those kinds of reasons. Now, she was lucky to not have been accused of anything, because if she had been, and if she had been found guilty, not only would she not have been able to bring her young daughter, she would have been inadmissible for 2 years. And under C-43, it would be 5 years of inadmissibility. So that's one concrete example. And so we think these are measures that are too strong.
Oh, okay.
My example
you know what? I'm actually going to ask that maybe we could get you to submit any examples that you have to the committee through the chair. And maybe just to finish up, do you think it's possible to make the deportation process for those we do want to get out of the country more effective without the changes made in this bill?
I don't think these changes are necessary because we already have a rule that says if you have a 2-year prison sentence, you don't have an appeal. Seems to me the ones that we're going after here are the less serious criminal offenses.
Thank you.
Thank you, Mr. Opitz.
Thank you, Mr. Chair. But even the less serious criminal offenses shouldn't be anyway. I mean, they shouldn't be coming to this country committing crimes in the first place. My parents came here, and Chunks and the Young came here, and so many other people in the House who've come from other places arrived in Canada, not saying, well, I'm going to live in this country, but by the way, I'm going to commit some crime along the way. Generally, most people don't do that, but some do. And some of those serious criminals have created serious crimes, including murder, including trafficking, including fraud, including assault. And a whole host and range of other crimes, and we do have a whole list, and I can go down that list. But and you're talking about the criminals, and again, I'm not hearing much about the victims. So have you actually talked to any victims groups about this and what their impact is, what the impact of these serious criminals on their families have been? Never mind the criminal's family. What about the victims' families and the impacts that it's had on them? I'm going to give you an opportunity to answer that. Have you talked to victims of crime from serious foreign criminals?
I have to confess no, and we didn't come here primarily to actually talk about the criminal aspects, but we are happy to talk about them because we have some experience. And I think the point is absolutely well taken, that it's not too much to ask foreigners, foreign nationals, to come here and respect the law. It's absolutely a normal expectation of Canadians. And again, I think it's just a question of proportionality. We heard briefly the previous presentation about sensational crimes. It seems to me when we're talking about murder, serial killers, and so on, this was already being dealt with by the previous legislation. We're here today to talk about how C-43 could improve things. I'm not understanding how lowering the threshold for right of appeal from 2 years to 6 months is going to have anything to do with serial killers and so on. Maybe you could explain that. And again, to show really what we're talking about, the people with the 6-month sentence are the kid next door who breaks in and drinks some of your liquor, or who breaks into the mall and steals DVDs.
Can I just add, yes, we do speak to victims. We speak to people who are victims of very serious offenses overseas. We saw the case of Leon Magusera, who was a Rwandan accused of crimes against humanity, and we have spoken to many of his victims. And there was a case of Desiree, what was his last name? The Rwandan guy that Canada did bring to trial, and it allowed and Canada's to be commended for having brought him to trial. And many of those victims were here, and some of them were brought from Rwanda to testify. We are not saying that people who are very serious criminals and crimes against humanity and victims of those crimes are here, that they should not be dealt with. We're saying that sometimes, and I'm sure you're going to end up seeing people in your offices, I'm not saying it to be facile. You're going to see people in your offices who are caught up in this, and you're going to say, well, this is not quite the person I had in mind. And you're going to be asking for relief for these people, and you're going to find that it's very hard to get it.
Do you believe that our justice system is fair and compassionate generally?
I think our justice system is generally fair and compassionate, but what we're doing here is denying people access to certain levels of justice and to certain levels of appeal.
Because I think, judges in their wisdom will screen out, a 20-year-old kid who steals a little booze. I mean, that's kind of trivial in what we're really talking about here, and that's the removal of serious criminals from Canada. Are you aware that other countries like the UK, the US, New Zealand, Australia, they have provisions in place already to bar individuals who would harm the public interest and who otherwise are inadmissible? And in fact, the provisions in a lot of those countries are far more broad and discretionary than Bill C-43. Are you aware of that?
Well, I was under the impression that I think it's the U.S. or the U.K. uses a 1-year threshold, which is, we would be going to 6 months. But again, I'm not claiming to be the world's expert on this. But once again, we just think that it's a question of proportionality. And again, on this issue of whether judges are prepared to look at immigration considerations, it seems to me I've read contrary jurisprudence on this. So if the committee is going to base its conclusions on the idea that judges across Canada are going to fully weigh humanitarian immigration considerations before rendering a sentence, I think you had better get very solid information on that before you go forward.
Well, these are the things and that's why we do have a justice system, so that people do follow due process. They will get due process out of this and be treated fairly for it. But do you think that the Canadian
I'm sorry, we have to move on to Mr. Meningakis. Sorry.
Thank you, Mr. Chair, and thank you to our witnesses. Clearly what we're trying to do with Bill C-43 is, again, try to keep foreign criminals out of our schools, out of our parks, out of our shopping centers, out of our neighborhoods. Keep them away from our families. The notion that somebody who breaks into somebody's home just to have some booze and that is not a serious crime can be quite extensively debated, because the real crime is you're breaking into somebody else's home. And if your child was in that home when that break-in happened, it would create, in my opinion, lifelong, potentially irreparable damage to your family, because that 20-year-old decided to break into your home. He didn't walk into the store and say, I'm going to take this pen and not pay for it. He broke into somebody's home. So I would ask that that example that you bring, I would suggest, is not a good example in your case. Neither is the case of invoking the name of Nelson Mandela, I might add, because we can get into a whole debate about that and whether or not we as Canadians were supportive or not of apartheid and the incredible crime that was done against the good people of South Africa. However, having said that, I'm going to go to Mr. Tom Stamatakis from the Canadian Police Association. He said that in his experience, criminals who receive a custodial sentence of 6 months or more have committed very serious crimes and are quite often repeat offenders. Do you agree or disagree with Mr. Stamatakis' analysis?
I don't know exactly what his analysis is based on. I mean, I can read the criminal code like anybody else and see that, you know, the examples that I gave could lead to a 6-month sentence. And again, we could debate how serious break and enter into somebody's neighbor's house to steal some booze is, but I think most Canadians would agree that if the young person in question had been in the country his whole life, came from a country like Iran or Eritrea, didn't speak the language, didn't write the language, then at least there should be some assessment of the humanitarian considerations. Maybe he'll be out the door at the end, but at least there should be some look at the humanitarian considerations.
Thank you, Mr. Goldman. Ms. Freeman has drawn to my attention that the clock at the back of the room has stopped, and our meeting, therefore, has come to an end. So I want to thank Ms. Ogenfield. Well, you know,
I was getting all excited. I thought I got a turn.
So, Ms. Ogenfield and Mr. Goldman, we thank you for your contribution. Could we have some order, please? We have some more work to do. Ms. Ogenfield, Mr. Goldman, thank you for your contribution to the committee. Thank you, and this meeting is adjourned. We're going to go into camera, please. And we are running out of time. Unfortunately, we didn't catch that, so we'll have to